74 bail is a rule, rejection is exception, which even now, my lords, probably would hold good. I have been in custody for
127 days then.
days. So they say 3 more months, then the liberty which is granted. Please notice the conclusion, my lords. At page 89, that's what we feel, my lords, allegations would be one and same. Presently, notice has to be issued at a pre-cognizance as against 2 to 4, and it is still at an early stage. Total number of witnesses in the original prosecution complaint are 8 witnesses, running to 11,400 pages, my lords. The first complaint, even to point out after 3 months, if there's no progress, you can approach this honorable court. Specifically,
Correct, that I saw.
yes, my lords. When that is a liberty granted, and now probably we are one step back, my lords. With the supplementary complaint being filed, you're again back to the pre-cognizance stage, not going forward, but we are one step back, my lords. And in the predicate offense, we are out on bail. And the events that have happened, lie down, my lords. Mohit Kumar, Mohit Agarwal, case of NDPS, punishment up to 20 years. 22 is the offense. Section 22(8), 22 is the offense. But here, my lords, here maximum is up to 7. And he's been in custody for 275 days.
Included undue gratification, bribe obtained by the accused person for making illegal allotment, charges are enclosed evidencing the manner of commission of the offences. A reference is made to the illegal allotment of 48 sites in favor of Chamundeshwari Nagar Sarvodaya Sangha, all of which were made by GT Dinesh Kumar, the petitioner, for prosecution. It is stated that when GT Dinesh Kumar was confronted regarding such illegalities during custody, he has admitted that the government of Karnataka did not grant any permission to allot sites to the said Chamundeshwari Sarvodaya Sangha through Muda, though Muda had requested. It is specifically observed that he has not provided any plausible answers to the fact that 3 out of 48 sites allotted in the case has been obtained by his relatives through sale agreements without paying any money. And also the fact would have to consider, cannot turn a blind eye to the existence of prima facie case against him. Is my responsibility.
Then, my lords, the supplementary.
Ask him to come. Let him.
But as I pointed out, my lords, the main ground would be the liberty granted by this honorable court, my lords, in the previous order.
No, Sandesh sir, you go from the beginning.
Please, my lords. My lords, can I request my lords to have the previous order of rejection of bail,
Page
346, annexure E, my lords.
346.
346.
Second petition.
It's in the second petition for bail, my lords, point 1.
Madam, ad kodi madam. .346.
346. My lords, the date of arrest of the petitioner.
One moment.
Yes, my lords.
340. Just Sunil Dutt Yadav.
Yes, my lords. Because the liberty which is granted there, that is the reason we have now filed this bail application.
All right.
Instead of touching the merits of the matter, I'll point out the liberty which is granted. And specifically, I'll point out, my lords, the bar under 45, the twin conditions, the court took note of it and then gave the liberty. So, my lords, my arrest was 16/9/2025, my lords. 16/9/2025. I've been in custody now for about 270 days, my lords. Now, in this order, my lords, various aspects had been considered, of which, my lords, the liberty which was granted was based on the fact that if in 3 months there is no progress, you can come before this court and renew this application. That, my lords.
This is from the date of the order.
Yes, my lords. From the date of the order.
This is 20th January
20th January 2026. Now it's about 6 months, my lords, though the liberty was 3 months.
All right.
Now, my lords, 388 may be noticed, my lords.
Page
388, Roman number 7.
Long incarceration.
Yes, my lords. This is the aspect between paragraph 64 to 98, my lords. This will be relevant. It's based on the liberty granted here is the present petition. Now, my lords, when the court considered this particular aspect of long incarceration, at page 389, the court falls back on Manish Sisodia's case, my lords. Now, Manish Sisodia's case, there were about 3 cases, 1, 2, and 3. In 1, my lords, when the rejection of the bail took place, liberty was granted. Once complaint is filed, you can renew it. But 2 was filed before that complaint was done, so court did not interfere. And 3 was filed after the complaint was done. Court granted bail on the sole reason on long incarceration. This is noticed by the court. My lords should notice, my lords, at page 389, starting with Manish Sisodia 1. Then, my lords, paragraph 69, page 395. 69, bail was granted on the ground of long insofar as Manish Sisodia is concerned.
Yes.
Then, my lords, the court notices section 45 will not come in the way if it is going to be a case of you being incarcerated for a long time. That at page 396, paragraph 70 may be noticed, my lords. Very specifically, they say the restriction under 45 would not come in the way if it is going to be a case where you are in custody for a long period of time. And paragraph 37 is extracted there. Thereafter, my lords, Manish Sisodia 3, we would get it at paragraph 72, page 398. The court extracts paragraph 52. And next page, paragraph 73, they reiterate section 45 would not come in the way for consideration of bail due to long incarceration and delay in trial. And, my lords, 74, bail is a rule, rejection is exception, which even now, my lords, probably would hold good. And along with this, the court also considered V. Senthil Balaji's case. My lords would get that at page 402, paragraph 79. Again, on the ground, same ground, my lords, 45 would not come in the way. Page 402, paragraph 79, line about 5 from the bottom, my lords. The reason is that 45(1)(2) does not confer powers on the state to detain any accused for an unreasonable long time, especially when there's no possibility of trial concluding within a reasonable time. This was noticed. Then, my lords, page 411, paragraph 86 and 87 may be noticed, my lords. 86 and 87. Then in 88, court notices that I have been in custody for
127 days. Then
days. So they say 3 more months, then the liberty which is granted. Please notice the conclusion, my lords. At page 89, the approach at page 412, paragraph 89, the approach of the apex court in Manish Sisodia could be adopted in the present case as well. And the court makes the observations. Then, my lords, 413, just after the extraction portion, would indicate that the apex court, taking note of the stand of the prosecution regarding trial, reserved liberty to the appellant therein to move a fresh application for bail in case of change in circumstance, or if trial is protracted and proceeding at a snail's pace in the next 3 months, or if the trial is not concluded within 6 to 8 months. This is Sisodia's case. Then, my lord, subsequently in Manish Sisodia versus Directorate of Enforcement, when the accused had approached the apex court once again, the apex court noticed that the period of 6 to 8 months fixed by the previous order not having expired, reserved liberty to review his prayer or to move fresh after the completion or filing of the charge sheet. Finally, apex court in the 3rd round of approach, whereby a challenge was made to the rejection by the High Court in Manish Sisodia 3, enlarged the petitioner on bail, recording that there was remote possibility of trial being concluded in the near future, that keeping the appellant behind the bar for an unlimited period to deprive him of his fundamental right of liberty. Then finally, paragraph 93, finally apex court proceeded to grant bail. Then, my lords, in the present case as well, having held that the length of incarceration cannot qualify to be a long incarceration.
then 127 days, para 97, it is said.
94, we have to show that there's no possibility of an early trial, my lords. That's the aspect. And then the liberty which has been granted. Now, my lords, this order was on 20th January 2026. Post that, my lords, I gave a note on 8 aspects, my lords, which are the changed circumstances that we see. Last time I gave an... Can I pass on one more?
1 minute, 1 minute. Yes.
The first circumstance, in the predicate offence, my lords, he is enlarged on bail on 16/3/2026. My lords, charge sheet is filed in the predicate offence on 16/3/2026. In the present one, ECIR, cognizance
Complaint is filed, cognizance is taken.
Then, my lords, after cognizance was taken, they filed a supplementary prosecution complaint against accused 2 to 4 on 28/3/2026. Now, this, my lords, is at the stage of pre-cognizance because 223 mandates. So we're still at that stage. Now, though supplementary prosecution case has been filed against 3 accused, ED has chosen not to arrest any of them, my lords. The accused is standing on the same footing as them. Insofar as allegations, that's what we feel, my lords, allegations would be one and the same. Presently, notice has to be issued at a pre-cognizance as against 2 to 4, and it is still at an early stage. Total number of witnesses in the original prosecution complaint are 8 witnesses running to 11,400 pages, my lords, the first complaint. Total number of witnesses in the predicate offense are 24 and running into 4 volumes. That's also quite voluminous, my lords. Then, my lords, the possibility of an early trial looking at what has happened is impossible, my lords. We have not progressed at all. We are still at the stage of pre-cognizance. Then I have been in custody now to close to about 275 days, my lords. That is from 16/9/2025. The offense is punishable minimum 3 years, up to 7 years is what the offense is punishable with. Then, my lords, I would fulfill all the conditions as per the liberty granted by the earlier order. So, my lords, I will restrict it to this aspect without really having to get into the merits of the matter. Merits of the matter, my lords, was pleased to notice, my lords, earlier in Muda case what has happened, where, my lords, similarly placed person, it was quashed. SLP was
That Natesh.
Natesha. SLP then was rejected.
SLP is not filed.
My lords, SLP was filed in so far as Parvati's
Correct.
and my lords dealt with that matter. So far as Natesha's matter, coordinate bench, while exercising powers under 226, quashed the proceedings. Appeal was filed against it.
Oh, that's pending.
That is still pending, but probably, my lords, with the SLP having been dismissed, the fate of the appeal may have to follow there, my lords, because my lords had considered the coordinate bench's ruling while quashing the proceedings insofar as Srimati Parvati. And so, my lords, I will not trouble my lords with the merits of the case on the basis of the liberty. Now 6 months have lapsed, my lords. And my lords, on just on changed circumstances that you have been incarcerated for a long period of time, along with the paragraphs we've just mentioned. All bails have been granted, my lords, even in heinous offences. Now, one other aspect, could I just point out on the statement of objection which they have filed?
They have
my
filed
lords.
objections.
They have filed the objections. My lords, insofar as the liberty that has been granted, nothing much has been stated in the statement of objections. Now, if my lords would kindly notice the statement of objections, they say mere period of incarceration cannot be the sole criteria, but the entire liberty which has been granted by this court is based on that. Kindly notice page 41, my lords, paragraph 37
Of the objection.
of the statement of objections. Statement of objection.
ಹಾಕಿದಾರ?
Paragraph 37 in there. 37, 38 ಎರಡಿದೆ. ಹೌದು, ನಿಮ್ದು.
It's here.
My lords,
Yes.
page 41 may be noticed,
Oh, ಇದಲ್ಲ.
because till then it all goes on the factual aspects of it, my lords. And page 41.
Madam, objections copy ಇದೆ ನೋಡಿ. PD ಹಾಕಿದ್ರು.
ಬೆಳಿಗ್ಗೆ ಅವ್ರಿಗೆ ಕೋರ್ಟಿಗೆ ಬೆಳಿಗ್ಗೆ ನಮ್ಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
No, it's not yet filed.
Give it.
That's
Morning,
what-
I think they gave to us in the morning.
ಕೋರ್ಟಿಗೆ ಕೊಟ್ಟಿಲ್ಲ.
ಕೊಡಿ. ಇದು ಬೇಲ್ಗ ಇನ್ನೊಂದು ಪೆಟಿಷನ್.
ಬೇಲಿಗೆ my
ಇದು
lords.
ಬೇಲ್ಗೆ ಮಾತ್ರ.
Normally ED, CBI, we are used to holding bigger bundles.
Bail is a rule.
My lords, page 41 may be noticed, my lords.
Page 41. of this.
41
All right.
of the statement of objections.
Objections.
Objections, my lords.
Yes.
Objections. I think very complaint and supplementary complaint.
Mere period of incarceration.
Incarceration.
Yes.
Kindly notice, my lords, 37 and 38. Whereas the very liberty was given on this basis. So 37, 38, they touch upon it. And then, my lords, their contention is we have to take into consideration section 45, which, my lords, at the time when the earlier liberty was granted, they say 45 will not come in the way when it is going to be a case of long incarceration. So then, my lords, the other aspect would be paragraph 58 at page 55. They say, yes, we have filed a supplementary complaint, but merely because we are continuing to investigate would not be a sufficient reason for consideration of bail. Paragraph 58. And one other paragraph, my lords, is paragraph 48, my lords, at page 50. They say, yes, there was liberty granted, paragraph 48, at page 50.
50.
50, paragraph 48. These are the only places we find anything to do with the liberty granted by the order dated 20th January. my lords.
But the contention would be that mere change of circumstance will not inure to the benefit of the accused to seek.
Yes, my lord,
Bail.
but here, my lords, when a liberty is specifically given to point out after 3 months, if there's no progress, you can approach this honorable court. Specifically, they
Correct,
said,
that I saw.
yes, my lords, when that is a liberty granted, and now probably we are one step back, my lords, with the supplementary complaint being filed, you're again back to the pre-cognizant stage, not going forward, but we are one step back, my lords. And in the predicate offense, we are out on bail. And the events that have happened, my lords, the 8 events which I have mentioned therein. And not on us, my lords, we are not the cause of any kind of delay. The order sheet may be seen, my lords, not one aspect of delay insofar as we are concerned, my lords.
Yes, AG sir.
There are a couple of judgments, not there on, they're getting printed. It is illa.
ಇಲ್ಲಿ ಯಾವ್ದೋ ಇದೆಯಲ್ಲ
There is a Mohit Agarwal with a 3-judge bench judgment.
ಅದು
of
ಒಂದು
this-
ವರ್ಷ
I'm sorry.
ಅಲ್ಲ, mere incarceration of 1 year will not be a ground to.
Though, Lord, that was a bench strength was 3 honorable judges. There it was under section 37 of the NDPS Act, which is parameteria with our 45. There, is your copy? Okay, good. Madam, this is cyber. Very long case in custody. Now, please have a look at para 18 of this judgment.
Mohit Agarwal.
Yes, para 18.
Yes, sir.
In our opinion, the narrow parameters of bail available under section 37 of the Act have not been satisfied in the facts of the instant case. At this stage, it is not safe to conclude that the respondent has successfully demonstrated that there are reasonable grounds to believe that he is not guilty of the offence alleged against him for him to be admitted to bail. Now, what follows is important. The length of the period of his custody or the fact that the charge sheet has been filed and the trial has commenced are themselves not consideration that can be treated as persuasive grounds for granting relief to the respondent under section 37 of the NDPS Act. So, Lord, the bench strength is larger as opposed to Manish Sisodia, which was a bench strength was 2. So, merely because liberty is granted, that does not mean that bail can be granted. The requirement of passing the rigors of 45, the twin rigors of 45 cannot be dispensed with, and that will have to be demonstrated. In fact, my lord, before the bail court, we were able to establish with prima facie evidence that the petitioner, the accused petitioner, had deliberately and contumaciously made allotments by overlooking the government orders, and there was evidence of him having received money and plots. So there is a large volume of evidence which establishes a prima facie case of having committed the offence of money laundering. Considering these things, what the special court had rejected, and although the order in the bail rejection by this honorable court does not refer to it, but and it focuses more on granting of liberty. But the fact of the matter is that the court was not convinced that he has made out a case. On the other hand, as prosecution, we were able to make out a prima facie case of and to demonstrate that he is guilty. And under section 45, the accused had to show that he is not guilty, and he has not made any such effort at all. And even before your lordships, merely using that liberty would not suffice. He will have to show, having regard to the prima facie case made out against him, as to how he is not guilty, and he will have to also demonstrate as to how the 3-judge bench jurisprudence would not apply to this particular case. In fact, my lord, in the statement of objection, would your lordship kindly have a look at page 42? I'm sorry, page 41 itself. At the page 42, I have reproduced a Delhi High Court judgment. I have extracted para 19 of Anil Kumar Agarwal, learned single judge of the Honorable Delhi High Court. However, as correctly contended by Mr. Hossain, there exists no universal rule that passage of 1 year in custody in and of itself confers an automatic right to bail. So, my lord, what is a long period of incarceration? There is no such universal rule. It depends on facts and circumstances. In Manish Sisodia, it was 17 months. That was treated as, in this case, 6 months does not even measure up to that. Therefore, my lord, my respectful submission is, it is yet one premature, and secondly, the petitioner will have to demonstrate as to how he passes the rigors of section 45.
ಅಷ್ಟೇನಾ?
There is also one couple of other judgments, my lord,
ಕೊಡಿ.
little later in the evening.
ನೋ ಪ್ರಾಬ್ಲಮ್.
Madhu is in appearing in the
ಆಯ್ತು,
trial
ತೊಂದ್ರೆ
court.
ಇಲ್ಲ.
ಅವ್ರು ಬಂದ್ಮೇಲೆ
ನೋ ವರೀಸ್. ಕೊಡಿ ಆಮೇಲೆ.
4:15 ಅಷ್ಟು.
ನೋ ವರೀಸ್. ಎಷ್ಟು ಸಂದೇಶ್ ಸರ್ ಅಷ್ಟೇ ಅಲ್ಲ?
The judgment which was relied on, my lords, Mohit Kumar, Mohit Agarwal, case of NDPS, punishment up to 20 years. 22 is the offense, section 22(8), 22 is the offense. But here, my
Peddling.
lords, here maximum is up to 7. And he's been in custody for 275 days. And also in the judgment that I have given, my lords, page 16, paragraph 14 to 18,
ಯಾವ್ದ್ರಲ್ಲಿ?
the judgment,
Mohit Agarwal.
Arvind Dham, in the R compilation, my lords.
Yes.
At page 13, the judgment starts 2026, Arvind Dham versus Directorate of Enforcement. Relevant portion would be, my lords, page 16, paragraph 14 to 18. Again, Senthil Balaji's case is considered.
Yes.
And 18 may be noticed, my lords. The right to speedy trial. And my lords, the order passed dated 20th January, where liberty was granted, that has never been challenged. It remains like that. Based on that liberty, we are here, my lords.
That is not challenged.
Of course, they have not challenged. If they found fault with the liberty being granted, my lords, they could have challenged it, but they didn't. We waited for that period to be over. Now it's 6 months, my lord, not just 3.
This one paragraph that I'd like to read.
In
in
Mohit
the-
Agarwal?
No, in the earlier order rejecting of bail,
Yes.
please have a look at page 363 of the petition. After referring to Manish Sisodia, para 20 of the judgment. The prosecution complaint is detailed and makes out a case against the petitioner herein. As regards prima facie case made out regarding the money laundering under section 3 PMLA, the investigation is stated to have revealed the following. 1, illegal allotment of sites in the guise of allotment of sites in lieu of compensation made to ineligible beneficiaries. Such allotment was made on the basis of false facts, forgery, cheating, and use of undue influence. 3, the illegally allotted sites constitute the proceeds of crime. Such proceeds of crime were layered, routed through power of attorney, sale deeds to obfuscate the true nature of proceeds of crime. The criminal activities associated with the scheduled offense included undue gratification, bribe obtained by the accused person for making illegal allotment. Charts are enclosed evidencing the manner of commission of the offences. A reference is made to the illegal allotment of 48 sites in favor of Chamundeshwari Nagara Sarvodaya Sangha, all of which were made by GT Dinesh Kumar, the petitioner, for prosecution. It is stated that when GT Dinesh Kumar was confronted regarding such illegalities during custody, he has admitted that the government of Karnataka did not grant any permission to allot sites to the said Chamundeshwari Sarvodaya Sangha through Muda, though Muda had requested. It is specifically observed that he has not provided any plausible answers to the fact that 3 out of 48 sites allotted in the case has been obtained by his relatives through sale agreements without paying any money, and also the fact that huge sums of money were received by his relatives N. Manjunath.
That's on the merit of the
I'm
matter.
not asking in this petition, it's for bail, my lords, not for quashment or discharge insofar as this
Please
petition.
establish a prima facie case.
What's the companion petition?
That's for quashment. That time we will deal with the entire aspect, my lords. And how he would stand on the
Washing
same,
ಕೇಳಿದ್ದೀರಿ.
how he would stand on the same footing as
respectful
Nakesha.
submission, my lord.
My lords, that we will argue it, my lords. In fact,
No,
there were
I'm
3.
only hearing the bail
The
matter.
bail matter.
My lord, my respectful submission would be, when there is such a serious case with prima facie evidence of generation of proceeds of crime, which satisfy all the different dimensions of proceeds of crime, including generation of proceeds of crime, layering, hiding, projecting it as untainted money, then my lord, even while grant of bail, just because he is in custody for 6 months, the court, my lord, would have to consider, cannot turn a blind eye to the existence of prima facie case against him, is my respectful submission.
Then, my lords, the supplementary complaint accused 2 to 4 never arrested. So if it
Same
was of
foot-
such a
same
nature,
footing.
they did not arrest. And they filed the supplementary complaint against them. Right.
That Najib and other Kalyan Chandrasekhar, I'll
I-
furnish it by 4:30.
You have quoted that in your objections.
Yes.
It's
other-
quoted,
but,
it's quoted, my lord.
It's
Najib
quoted,
is quoted.
but the relevant part I would like to, it's a recent judgment. I would like to
You
read it
give
and then
No problem. Heard reserved. Yes.
Deeply obliged.
Only the bail one.
Yes, my lord.
Yes. ಅದು ಯಾವ್ದು serial number?
110.1.
100 point?
1.
10.1.
10.1.
110.1.
10.1. So 110.1 is reserved.
Yes,
110 list after 2 weeks.
please.
Heard, so senior counsel, additional solicitor general. Yes. Yes.
Deeply obliged.